Hello, everyone, and welcome to MediaNama. The Supreme Court of India on March 21 put a stay order on the fact check unit notification that was issued by the Ministry of Electronics and Information Technology, which was basically going to go ahead with the creation of the fact check unit under the Press Information Bureau. Now, for those of you who haven't been following this story for a while, let me just give you a quick breakdown of what has happened so far in this year. So, on January 31st, the two-judge bench from the Bombay High Court gave a split verdict where Justice Neela Gokhale spoke in favor of the rule for the formation of a fact check unit, while Justice G.S. Patil spoke in favor of the petitioners. Following that, on March 11, basically what happened was that the judges decided to send this case to a third referral judge to give a third opinion, which would then help get a majority view on what decision needs to be made over here. And on March 11, Justice A.S. Chandurkar gave the comment that a stay on the formation of the fact check unit is not required. And based on that, the two-judge bench also decided that with a majority view, they will be rejecting the stay order on the fact check unit. And in line with this, on March 20, MIT notified the FCU under the Press Information Bureau on March 20th. Now, as I told you, the Supreme Court, after hearing a plea by the original petitioners Kunal Kamra and the Editors Guild of India, decided that a stay order is in fact required on this front. So basically, what this means right now is that until April 15, which is when the next hearing by Justice Chandurkar is expected to take place, until that date, the stay order on the FCU will continue. Now, what does this mean in terms of free speech in India? We will now be discussing with our founder, Nikhil Pava. So, Nikhil, hi, thanks for joining us. Nikhil, how do you interpret the stay order on the mighty notification of the fact check unit?
So the stay on the formation of the fact check unit is actually very welcome from the Supreme Court. I only wish that acted sooner on this issue because this is amongst many key constitutional matters that need to be taken up. I was very worried when the third judge's ruling and the refusal to stay the formation of the fact check unit at the High Court level, because once something like a fact check unit is set up, it's very difficult to roll back. We saw this with Aadhaar, right? So the Supreme Court took over 700 days to even hear the right to privacy case in that instance, um, and to form the 9-judge bench, and then by then the penetration of Aadhaar in the country had gone up from around 60 odd percent, I think it's 63, 64% to above 90%. And once resources have been allocated, people appointed, people are on board, it's difficult to roll back something like this. The fact check amendment by itself is a serious threat to freedom of expression because it gives the Indian government um, power on social media, over social media, to direct social media platforms to censor any news that has been fact checked by the fact check unit. So now, whether it is factually correct or not, and this is something that we've seen with the way the Press Information Bureau's fact check unit had been operating for a while, and that's the one that was being designated as a fact check unit. It seemed very political in nature in terms of what it was fact checking. Um, and if you can't really uh, give the government the power to censor content on itself, especially when there are news organizations that are critiquing it. In that context, let's not forget that the first of the IT rules amendments in 2021 basically brought digital news organizations under the ambit of the IT Act, and they gave the Information and Broadcasting Ministry the power to regulate them. And in that regulation, basically what had happened was the government had expanded the scope of Section 69A, which are its secret blocking powers, to digital news organizations. Now, multiple news organizations went to court to challenge those rules, and got a stay order. So effectively, you can still the government doesn't have the power to direct uh, under 69A. They don't have the power to direct news publishers to delete stories. But and because this was stayed, which is why, is my reasoning, they tried to create this fact check unit, because that would apply directly to social media platforms and other intermediaries, where they can direct an intermediary to censor content online. And for news organizations, most discovery of news happens through search and social. So it has the same impact of censorship, because social media platforms are essentially distribution for news organizations. So it's censoring the spread of the news, not the news itself, but it has the same impact that people don't read it. So I think in this country, TV and print are declining, and mostly people read the web. So this is the fact check amendment was brought in to bypass that staying of Section 69A censorship powers. Um, Again, like I said earlier, one of the big problems with this fact check amendment is that it basically makes the government the sole arbiter of truth in relation to any business relating to itself, um, and so it makes it the gatekeeper essentially on the internet, that you can't, let's say, if you're critiquing the calculation of GDP, or if you're pointing out how the government may have misinterpreted its own data, which it does quite often. Um, and 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 if you're highlighting those things as a news organization, then you would the government would have the right to censor you. So uh, especially when we're going to elections, it's very important to prevent the creation of such a fact check unit. And I'm quite, if you look at the speed with which the government set it up, because then it has the ability to remove from social media news reports that could perhaps highlight issues related to the government, especially after, for example, there is interpretation of the electoral bonds data that's being made on the internet right now, right? Um, the uh, the other is that there is no clear definition of words like fake or false or misleading in law, and this basically uh, uh, just and also the perpetuity of this content, in terms of the fact that if uh, if it's censored once, can I paste it again, and will it have to be censored again? So is there, like, our social media platforms expected to continue censoring resharing of news articles on social media? And where is the ability for them to do that on a repeat basis, right? So it leads to, in a sense, shadow banning or prevention or distribution of critique of the government, especially close to the elections. um, the other thing is the impact on safe harbor. So digital platforms currently enjoy safe harbor from liability for user generated content, which means that if you and I post something on social media, we're not held liable for what the platform is not liable for what we post. And this can be taken down by platforms, but that or the platforms can, if the platforms don't remove it if it is illegal, um, they and after they're informed of this information being illegal, or uh, is when they have actual knowledge of it. Now, under the Supreme Court verdict, actual knowledge means a court order or a government order. So a fact check unit informing someone to take content down um, uh, is effectively overriding the uh, 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 Section 79A of the IT Act. Um, and they're saying that platforms don't necessarily need to take this down as well. Um, but the way you need to look at how this operates is that The moment a platform will get, let's say, 100 orders asking them to take down certain content, they don't have the capacity to do. They can't challenge it. So even if the government says mark this as fake news and don't take it down, they may still have liability over that fake news, and so therefore they might take it down and censor it themselves. So the effect is that also that of basic censorship. Valerie?
Okay. So there's this argument that was made by the Solicitor General Tushar Mehta. Basically, when the petitioners were saying that the rule could make a singularity of truth online, Mehta's argument was that the government is not forcing the intermediaries to take down the content, but rather that after the whole issue goes over and there is an aggrieved person, if that aggrieved person wants to approach the court against the intermediary, then the intermediary cannot hide behind the Section 79 safe harbor provision. So, what is your take on that?
So look, there is clear liability that gets attributed if, let's say, um, the intermediary does not take down the content. And like I said, the intermediaries will not take a risk in allowing that content to stay up because they don't want the liability. The threat of liability is enough for most to force most intermediaries to take down content. And we're seeing this happen. We've seen this happen in the past. Like Rishabh Dara had done the seminal research work almost a decade and a half ago, almost a decade ago, in fact, on safe harbor. And what he found was that just at that time, you didn't need a court order, a government order to get content taken down. You could simply send an email. And what we found was that platforms were unwilling to take on the liability. So while Tushar Mehta, the Solicitor General, may have argued that there's no compulsion to take down content, the threat of liability is enough for them to remove it. Um, and that's the risk that you want to avoid, because what happens is every time the fact check unit sends something, and there is no guideline for transparency, accountability of the fact check unit. It's not an independent body. Frankly, I don't think it should exist at all, uh, because it just it creates um, uh, an arbiter of truth, so to speak, that the government runs. And so we really shouldn't actually be in a situation where safe harbor is being risked by a government-run body that basically wants to prevent spread of news or information related to the government. The government has every right to counter it. They can publish their own counter speech. They can publish their version of the truth online, since interpretations of data and information may vary. But really, the government's argument that they are in the best position to determine what is true about them, um, is problematic, because we know, both from India and from across the world, that governments lie. And what will happen is that they'll basically end up suppressing the truth.
Okay, so you said that according to you, the FCU shouldn't exist at all. So, just to play the devil's advocate, social media intermediaries have their own community policies that allow content censorship to some extent. So the government could argue this is the same. This is their way of making sure that they get to fact check the truth about themselves. So what
And
would you
social
say to
me-
that?
and social media platforms get criticized when there is censorship of content on their platform, when they censor certain content. A classic old case, for example, of legitimate news being censored was this instance where I think it was a Norwegian prime minister who had uploaded um, the photograph, a Pulitzer Prize winning photograph of a naked girl child running with a napalm bomb in Vietnam going off. And this was one of the most celebrated photographs published in a newspaper um, from the Vietnam War. Um, and Facebook took it down, they censored it. Should they have censored it? Their community guidelines said that, putting a photograph of a naked child is not correct. And that's something which we expect that wouldn't be allowed. Um, But if a newspaper can publish it, then why can't? And this is an iconic historic photograph. Why can't it be published on the platform? So look, platforms have their own guidelines. They have their own rules. These are all tricky situations. And that's why Facebook has also constituted something called an oversight board, which is a space where users have the ability to question takedown of content by Facebook, and there is an independent sort of group of people that adjudicates on this on a regular basis. I'm not. It's. I mean, it's jokingly called the Supreme Court of Facebook, and I'm not sure whether that's the right approach or what is the right approach here. But I think Facebook doesn't even need to do this because there is no clear legal requirement to do this. But they have it because they want to give the semblance of fairness, and they also have the right to not abide by the directions of the oversight board as well. But it allows them to become better at what they do because there's a feedback loop that's coming from a number of global experts on these issues, right? What so I And the other thing is that should Facebook have the right to censor content that's on, right? Should they be forced to abide by, let's say, what the Indian Constitution has in terms of reasonable restrictions on free speech, and say that they don't, and that they can't take down content which is inherently legal. Our conversation today is on whether the government can force a takedown of content that they feel is fake. But should Facebook be prevented from taking down content which is essentially correct and legal in nature? And it's tricky because what's happening is that platforms like Facebook, Twitter, um, YouTube are very large platforms that are dominant in their own right, in their own space. And so, and they are essentially the carriers of speech. They can be the arbiter of truth. Their algorithms can change the way we view stories and what to prioritize, what not to prioritize. There are allegations of shadow banning. They are essentially private platforms performing a public function. So, should they be held to a higher standard, like the government of India is under the Constitution of India? I don't really have an answer to that question. It's a tricky one because at the end of the day, they are a private platform. It's their playing field. If users feel that on this playing field there shouldn't be that the platform is not being fair, they leave the platform. I barely used Facebook in the last, I don't know, 5 years. Barely ever logged in to Facebook. I prefer Twitter as a platform. So different people will choose and respond in different ways, but at the end of the day, it is a private platform governed by their own rules. And I don't see how the Constitution of India applies to a private platform. It does apply to the government of India. The reasonable restrictions on free speech apply to the citizens of India, but overriding them to quite an extent are the aspects and what is actually primary. What takes primacy is the guarantee of freedom of speech that Article 19(1) gives us, and the government of India has to respect that and abide by that, which is what um, the fact check unit can actually override. Because let's not forget, um, the restriction on false information doesn't is not a reasonable restriction uh, under 19.2. There is what is fake and what is false is not mentioned. These definitions are not there. Um, so what is the let's take the amendment itself, right? What is the business of the government? What is fake? What is false? What is misleading? Um, Misleading is very subjective. Um, there are very few absolute truths in a sense, right? So what a government can choose to act on could also be how someone may have interpreted something that the government has done. So I think those restrictions that apply to the government should apply to the government. I don't think social media platforms necessarily should be restricted in terms of forcing them to abide by a country's fundamental right to free speech. It's their platform. Any user can create a Facebook on the internet. Uh, but there is only one Indian government for the citizens of India.
So, should there be absolute free speech online?
Uh, I don't think so. I mean, there is very clear harmful speech should be regulated. It should be restricted. There are mechanisms available to restrict that speech. It's another thing that globally we are struggling to deal with that speech because of the scale at which harmful speech is being published on the internet. And that's a battle which I think is impossible to win, to be honest. And so technology is also being evolved to deal with it. Um, but I think it's going to be forever a losing battle. Um, I'm not sure how uh, I looked at thought about that absolutist question uh, quite often. And there's an old saying that um, uh, if uh, if my so the right to offend is integral to the right to free speech, um, but no one has a right to illegal speech. And so, while uh, legal speech that offends someone should definitely be allowed, illegal speech should not. And so, I don't think there should be a right to absolute free speech. I don't think there should be the right to illegal speech. Um, our speech as citizens of India is restricted by our constitution, and I think that's where it should be. How the constitution is interpreted and how legal speech is determined legal or illegal is actually determined by courts. I don't think that should be left to the government of India.
All right, fair enough. Coming back to India, how do you see the development so far impacting the state fact check units?
Unfortunately, it doesn't impact the state fact check units. I don't think state fact check units should exist because just like the central government shouldn't be an arbiter of truth and have the power to get content taken down, the state fact check units shouldn't either. Of course, I think the government, even though I don't like it, I think the government is free to run their own media publication, so to speak, and their own fact checking center where they can say that something is false. But just like they have the right to say that something is false, uh, I should have the right to clarify that it isn't false. And But they shouldn't be able to censor me. Is the point. So uh, I, I I think similarly, state fact check units also, if they want to present the government's point of view, so go ahead. That's the job of a PR department. That's the job of PIB in the central government. But I don't think they should have the right to censor anyone. And so this entire move to set up fact check units is extremely problematic, irrespective of whether it's a state government or a central government that's creating this.
Are there any other censorship concerns that you're seeing these days?
Uh, I am a bit concerned about how Section 69A seems to expand in its scope, or we don't even know whether it's expanding in its scope. So, one of the things that happened on Twitter after Elon Musk took over was that they stopped publishing data to chillingeffects.org, or as it was called the Lumen database. It was initially called Chilling Effects, it's now called Lumen database. Twitter stopped publishing the data there, and Twitter was one of the most useful sources for us as journalists to determine what kind of censorship is happening in the country. And I've been using the Lumen database for quite a long time. Um, and I remember when the farmer protests were happening and there was this tussle between Twitter and the Indian government. Um, we used data in the Lumen database to figure out that there was a member of parliament who had been censored, and we contacted him, and he said, and I think his son was managing his Twitter handle. Um, and his son had no clue that that tweet had been censored. And then that particular MP raised the issue in Parliament about a member of Parliament being censored by the Indian government. And we saw censorship of tweets extensively there that were from media publications. Um, and the government clearly didn't want news about the farmer protests to be spreading online. It is believed, a great deal of control over mainstream media. So, therefore, protesters have no place to go except the internet and especially social media. And so, I think we're seeing now it's a black box. We don't know what the government is censoring. We don't know who's taking those decisions, how are those decisions being made. If something is taken down, there is no page also that indicates that this content is being taken down. You know, in Kuwait, when a website gets taken down, then the government puts up a page saying this has been taken down on the authority of so and so, etc. So there's detail that they provide to a citizen, and there should be an opportunity for the citizen to appeal this against the government as well. But 69A orders are basically a black box. We don't know how this is being done. We don't know uh, on what basis an order is an emergency order, and most of these orders are emergency orders. So there is 69A censorship. I think is where the Supreme Court failed us in the Shreya Singhal case. They could have brought in more transparency and accountability. They seem to feel, Justice Nariman in his judgment seemed to feel that there are enough safeguards in place, and the government committee is in a position to review these orders, even if they are emergency orders. And we don't know whether those reviews happen and how those reviews happen, and whether it's basically the government just saying yes to a government order without really applying their mind. Um, and Justice Nariman had also written that the person whose content has been censored, if identifiable, should obviously be given a hearing. Uh, my understanding is that uh, that never happens. The platforms get a hearing. The platforms get summoned if they don't take that content down. So, in that sense, that's one problem with Section 69A and how it's being implemented on the internet. Related to that is Twitter's court case, which they lost, I think, in the Bangalore High Court, related to censorship, and that was problematic. And I hope that gets overturned eventually, um, because that basically legitimizes this kind of government censorship. Um, and I think it's about time that the Supreme Court looked at the IT rules in total, because there are multiple cases that are with the high courts. There are a few cases that are in the Supreme Court. All of these are linked to the IT rules, and effectively the IT rules are ultra virus of the Constitution, in the sense they create definitions and enforcement mechanisms under Section 79A of the IT Act when they can't do that. Section 79A defines due diligence requirements, and so this it's problematic how how the government is now regulating using advisories and FAQs and IT rules, which are not especially when the rules are not legal, um, without checks and balances, and people have to go to court to challenge them, and then takes years for them to be overturned. And by the time they're overturned, the government can just pass a new Disciplinary Act and legitimize those things, and say that Parliament, uh, has created this law, and then you'll have to go to court again to challenge the law. So the speed with which the government can create rules, regulations, and enforce them is far greater than the ability of our courts to deal with the effective illegality of these issues. And that, for me, is becoming a very, very worrying trend. And we might see more of this even after the Disciplinary Act, because of what we've seen in the data protection bill, that the government has given itself almost, multiple aspects have been just delegated to new regulation or to the rules. and which means that rules get tabled in parliament, they can get criticized, but they have to be reviewed by a committee on subordinate legislation. Um, and anyway, laws are also being passed in parliament without the government paying much heed to debate, so there aren't many amendments. And so broadly, the framework that we're seeing from a legal perspective that enables censorship is becoming more and more powerful, and the centralization of power with the government that allows them to do whatever they want, to be honest. And that's becoming extremely worrying uh, in terms of the rules and regulations we're seeing. I don't know how this is going to be solved, but we are going to elections, and perhaps there's a democratic solution to this problem, because an all powerful government is creating rules as and when they want and how they want. Um, and there isn't sufficient public consultation. There aren't enough checks and balances. And courts don't have the capacity to act fast, it seems, or perhaps the inkling or the inclination to act fast enough. So it's a worrying situation.
Right. Um, Final question regarding the fact check unit. What, according to you, are the potential implications of this rule and the fact check unit on the journalistic practices in India and the press freedom in India?
So, like I said, one of the things is that it basically censors the spread of news, because the government can censor it on social media. See, the difference between online news and print publications is that online news can sustain. It can sustain. It has a high shelf life. It can be read 10 years later as well, right? So the focus of the government is to deal primarily with online news, because if it's out in the paper today, you won't read it next day or after 15 days or after 1 year. Whereas on the internet, it can be found, it can be read, it can be shared. And the implication here was to prevent the sharing of journalistic output. Um, the other thing that would happen is that it's in a sense, um, a fact check unit can override a journalistic um, uh, output, and so your reporting on the government might actually get impacted or reduced, because if you feel that the sources that you're citing and the interpretation that you're citing is going to be treated as fake or false by the government and taken down, um, then that effort that goes into reporting it seems worthless. The other thing that the fact check unit does, and Justice Patel in his judgment mentioned this, that it basically creates uh, two typologies of content, two information classes. One set of information class which is news related to the government, and other that is not related to the government. So news related to the government can be censored by the fact check unit, and the rest of it needs to go through a separate process altogether. Um, and so it just makes it easier to censor government news, which means that the propensity to publish news related to the government, especially if it's critical, goes down. So from a journalistic perspective, uh, it life becomes tougher.
Right. Just to add to that, the EGI's legal counsel had also mentioned that investigative journalism is going to become more complicated in that sense, because which sources are we going to talk to, and how are you going to give weightage to that? All right. So thank you, Nikhil, for sharing your inputs here. MediaNama will be coming up with a longer copy on what exactly went down in the hearing. So for everyone here who came in to listen to us, thank you. And for more information on what happened on the fact check unit front, please do follow MediaNama. Thank you.